Okay, I overrule the objection. You bring the jury.
Your Honor, before we bring the jury in, I think the next witness.
Well, let's finish this witness, if we can get through with it. What about the next one there, while they're coming?
It involves the employment records of Walter Scott. Again, we have filed a motion to keep that character evidence. We believe the next witness who testified about the employment records of Walter Scott
All right.
is going to present an admissible character evidence.
Okay. All right. Thank you. The objection is overruled. You may continue.
I believe I was asking you if you had had an opportunity to review the family court records of Walter Scott.
Yes, I was provided a copy of the 2000 case file and a final decree of divorce and final order.
With respect to the bench warrant, did you have an opportunity to review that?
I reviewed the bench warrant issued in the 2000 case, I believe in January of 2013.
Thank you. I want to show you what's been marked as defendant's exhibit for identification, 59.
Yes,
And could you tell us what this is without going into detail?
that is the bench warrant issued in the 2000 case.
Now I'm going to ask him, since this is state's, excuse me, evidence.
Any objection?
May I say it, Your Honor? I believe it's already in evidence that states 224.
So, Ron would ask that this be accepted into evidence.
And the question for the state was, are there any objections?
No, sir, Your Honor. I believe
Submitted
it's
without objection.
You have also reviewed the documents that led to that bench warrant, is that correct?
Yes, sir, a civil contempt order was issued, I believe on the same day, by a family court judge.
And have you reviewed the family court records going back several years before that?
In the 2000 case, yes, sir, and then that final decree of divorce and order of the court.
Now, when you refer to the 2000 case, the jury doesn't know what that means. Would you explain, when you use the term 2000 case, what are you referring to?
I'm sorry. Lisa Scott, who was a plaintiff in a 2000 case, filed for divorce in 2000. It was given a 2000 case number. That case lingered on, like a lot of family court cases do, and eventually it was stricken by the clerk of court at some date due to the, said on that order, a 270-day rule, which I guess meant at that time, because that rule is no longer in effect, we have a different rule, that had lingered for 270 days and it was stricken, but that the temporary court order stayed in place. So there's a 2000 court order that they were still operating under, but then they did not get divorced until a subsequent case, and I believe it was 2004, but it was a subsequent case. So they had a continuing court order, but that's what I'm referring to, the two different cases.
Ms. Hazelden, are you familiar with what has been marked for identification? 5060.
This is the 2000 case file for family court.
You may use that file to refresh your memory, if you will. Were the parties ever divorced?
Yes, eventually in a separate case.
And the initial agreement, I guess, if you will, goes back to 2000 in terms of the amount of child support.
There was a temporary order issued by the court in that original case, and it did set an initial amount of child support.
And between the time of the divorce and April 4th of 2015, how many times, if you can look, that case went back to court?
Objection, no.
Objection sustained.
Did the family court judge have an opportunity to review the facts and circumstances of the child support payment on any occasions between the divorce and the issuance of the bench warrant?
Yes.
And on those occasions, based on your general knowledge, would it be the same as you testified to earlier? Mr. Scott would be entitled to the same privileges of anybody who is brought before the court on a rule of show cause?
I'm not sure I understand your question, I'm sorry.
The bench warrant is to bring somebody before the court.
Yes.
Is the language on the bench warrant that's been introduced as states 59,
Okay.
is the language in there to say, put this person in prison, or does it say, bring this person before the judge?
Well, it states on its face that you make diligent search for the above name, take him to the county jail where he will be safely held until he may be brought before this court or otherwise discharged by due course of law.
And would that then employ the same discretion of the judge that you had testified to earlier?
As to the actual rule to show cause proceeding?
Yes.
Yes, at that point, presumably Lisa Scott, the plaintiff, would have been able to present her case, and Mr. Scott, the defendant, would have been able to present any mitigating circumstances or defenses he might have had.
And that would include his employment status at the time?
I would assume.
And you had testified earlier that people who are employed can continue in that employment depending on the facts and circumstances of the case.
It is an option.
Kindly answer any questions that the prosecutor might have.
Certainly.
Good afternoon.
Good afternoon.
Don't have many questions, but on Saturday morning, April 4th of 2015, well, let me ask you this question. No question from your review of the file that Mr. Scott had an outstanding bench warrant on that day, April the 4th of 2015.
That would be correct. It was issued in 2013 and was never served.
And when it was, had it been served on the morning, Saturday morning, April the 4th of 2015, where was he going?
I would assume Charleston County Jail.
He wasn't any family court judge, was he?
I'm not aware of any that would have been on the bench on a Saturday morning.
That's correct, because they don't operate on Saturday morning then.
Not that I'm aware of.
So he goes to jail, correct?
Yes, sir.
And he stays in jail till the court decides they're going to bring him over, correct?
Yes, sir.
Might be Monday, but probably not.
It totally depends on the court's docket that week.
Could be a month later.
It could be, it typically not, but it could be.
Okay. And then it depends on who the judge is, right?
Absolutely.
And there are a lot of family court judges out there that he's going to stay in jail.
Well, it's stated in the law, in case law, that the goal is to get that money. It's not to punish. Even though it ends up feeling like a punishment. And there are a lot of judges that if you have somebody that had a bench warrant, they're going to order them to go to jail.
And don't want to cast names, but there's a good Judge Garfinkel that I used to work for example. He was not one of the ones you wanted to go in front of, was he?
Absolutely not. Good Judge Garfinkel put a client of mine in jail once.
And he's more in the category, they're going to jail for up to a year, right? Or is it 6 months?
It's up to a year, but typically they put them some shorter time, but they could pay the money.
Right. They can always purge themselves by paying the money, correct?
Well, it's not
You-
required, but yes, sir.
In the typical sentence, I'm giving you a year in jail for contempt, but you can purge that by paying all your child support arrearage plus, a fine or whatever they want to do, right?
That is a sentence. It's not a typical sentence to hammer them with full amount of jail, full amount of this, full amount of that, full amount of that. But it's certainly possible. I mean, anything's possible in family court.
Because a lot of times the family kind of come up with the money and
Yes,
get them
sir.
out of jail, correct?
It's amazing how money appears.
Okay. So a lot of judges like that, put them in jail until they pay the money.
Yes, sir.
Or if he has a job, then yes, it is possible that he could get work release, correct?
Yes, sir. Well, it's weekend time. It's not per se work release, but yes, sir.
He's gonna be serving time in jail one way or another.
Most times. There's a million different options, but yes.
And it may not be in the state penitentiary, correct?
It will not be in the state
Because it's in
penitentiary.
the county jail.
A
correct?
local detention facility. Yes, sir.
And, but if you're locked up, you're locked up.
Seems the same to me. It's not, but it's close enough.
Thank you for having me.
Anything further based on the cross-examination?
No, sir.
All right, thank you. may
Thank
step
you.
down. What's your next witness?
Ron Franklin.
And this is the issue that we have a matter of law concerning.
All right, ladies and gentlemen, we'll have you go to the jury room again. Please do not discuss the case. Yes, ma'am.
Your Honor, if I can hand up to the court, I asked Mr. Savage regarding this witness who is similar to a custodian of records regarding Mr. Scott's employee records from a place called St. Germain, I believe it is. I've flagged some of the pages that I believe are records, the probative value of these records outweigh the prejudicial effect, and we would ask that they be excluded on that basis pursuant to our motion of October the 11th. We have no issue as far as chain of custody of records custodians. The authenticity is not what we challenge, but we do challenge, again, the relevance and the probative value of putting in employee records from 2012, and then again from November of 2015, some almost 6 months before April 4th, regarding cocaine use. We just don't think it's relevant, and think it's unduly prejudicial.
Says the defense.
Thank you, Your Honor. There are a number of documents, and if they're in the same order, I will go through them with you. On March 19th, St. Germain is the document heading. 2012 would indicate that Mr. Scott was hired at that time. The importance of that is that he had a job. The last document in that group to show that the amount of money he was making was in excess of $50,000 a year on the dates in question. When the bench warrant was issued, that he had the ability to pay. In accordance with Ms. Hazelton's testimony, if he was employed and had the ability to pay, he could purge or partially purge or at minimum receive weekend sentence. That is the relevance of those documents. The second document is the welcome aboard. This is a document we believe that the testimony would be that this information was provided at the time that Mr. Scott was hired. It gives some personal information that would be placed on the bulletin board at the workplace. That it gives his history, prior employment, and a very brief statement. It also gives a very brief statement about how he would be employed at St. Germain. It also says in his spare time, Walter enjoys singing, working out, and martial arts. And then it talks about his children. So that document, the relevance would be his physical prowess. As of April 4th, 2015, the fact that he was a weightlifter, and also that he was skilled in martial arts. The third document is his application for employment. We don't think that that's necessary if there's an objection. The next document would be dated November 6, 2014, where he was terminated following a deep on-the-job accident. Drug test which was taken on Wednesday, November 5th, 2014, which is positive for contraband substances. The purpose of that is to show that he had drugs in his system on that date, and we expect to have testimony from the medical examiner who would indicate that the pattern of drug behavior, multiple uses of drugs, creates a different reaction to drugs than an occasional recidivist
I sustain the objection to the admissibility of these documents at this time based on a Rule 403 analysis, which states that although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The evidence, the profit here for admissibility in this case is speculative in nature as to whether one thing proves another. The fact that he was hired on March 12th, 2012 is not probative to prove he could afford child support without evidence presented, such as the nature of a family court judge, and we're not in family court. The family court judge would consider the fact that the employer or someone put out a flyer saying that he enjoys singing, working out, and martial arts, has no probative value as to his strength or physical ability on April 4th, 2015. The employment application has no relevance. Likewise, the letters indicating drug being terminated for failing a drug test on November 6, 2014, a document in which he refused to sign, has no probative value considering the prejudicial effect. Same being the screen report and other documents attached, including W-2 forms. If there's admissible testimony allowed at some later point in this time in the trial, then some of these documents may be reconsidered for admission, but at this time I grant the state's motion in limine.
Thank you, Your Honor.
May we mark these, Ron?
Yes.
You want to use them? Well, I think these are the same. Sorry. These are the same.
Yeah, you gave me this copy.
Well, the copy that was handed up here, you can give us that back. The copy that was handed, I can have that back, please, unless you don't have a copy and have to have it.
Look at the numbers real quick. 2777 through 2814.
All right, ready for the jury? Bring the jury.
Judge, that's all we have for today, although Don has matter.
Yes, Judge, before the jury gets back in here, we've been found another case or battery, the court would indulge a recall of Professor Kroll for the limited purposes of seeing if this third one works. We would try that before we heard the jury was coming back out very brief, less than 1 minute for them to see if this, if the taser performs. If it does not, just try, we're done.
Says state.
Got it, that's fine.
All right, what do you want to do?
Judge, I think it would be wise if we could keep the jury out there. Like I said, I don't want to waste their time. If we could have Mr. Kroll.
Well, the jury be fine, you just need to go ahead with what you have.
Oh, okay. So the state would, pardon me, the defense would recall Mr. Mark Kroll.
Let's have them hold the jury outside the door for a second.
Judge, does he need to be re-sworn or anything?
No.
Okay. Mr. Kroll, I'm going to hand you battery, and I just want you to test that very quickly to see if that works before we get the jury and make them set through another dry run that doesn't work.
Weak but functional. That's looking better. Warming up.
And Judge, if the jury would come in, would be very brief.
All right, ladies and gentlemen, this witness has been recalled. You may proceed.
Thank you, Honor. Professor Kroll, we found one more taser battery and would like for you, if possible, to demonstrate to the jury the operation of the drive stun mode of the taser. Have you placed that battery in the taser?
I have.
And are you prepared to demonstrate to the jury what the arc looks and sounds like?
I am.
Okay, and once again, if you wouldn't mind doing that, we'll, for the jury's purpose, we'll start pointing there and then just let them have a look at what both the lights, the laser, and the arcing looks like.
It's hard to see, but there is a ambidextrous safety. There's a switch on each side, and this is flipped up with the thumb. So if a right-handed officer would flip this up with the right hand, flip the thumb up, and now that turns on the flashlight, which you can see. It's not, this is a well-lit courtroom, so it doesn't show up real well here. And then you see the target laser.
Okay, would you display what the arc looks like when the trigger is pulled? And how many cycles per second did you say an average one would be?
18.3.
And is that sound from the taser a distinctive sound that can be brought out from, distinguished from other background sounds that might be on any recordings?
Usually, yes. It's-
And what is the significance of the volume or the lack of volume of the sound?
If you have a good connection, I explain the difference in volume between good and bad connection? I don't think I'm going to mark this. If I do, I'll be happy to buy a new one for the court.
Are you comfortable with the fact that you're safe in performing this demonstration?
It usually works. And with this big plastic handle, I'm feeling better than my normal trick with the Coke can.
Okay.
Okay. So when I turn this on and I have a good connection, it's only 50 decibels. It's I'm going to be really careful now because I usually mess this up. So you hear a little click. You can hear it, but it's only 50 decibels. Like a vacuum cleaner, I pull it away at 80 decibels. It's much louder.
Thank you. No further questions, Professor Kroll.
Last thing?
Nothing further.
All right, thank you. You may step down.
Thank you, Judge. Should I? Let's take this battery out.
Sir, if you just step down, that'd be fine.
It's still hot.
Ladies and gentlemen, that's it for today. We'll need you back at 9 tomorrow morning. Please do not discuss the case with anyone. Allow anyone to discuss it in your presence or do any form of social media or other media type access to information concerning the case. Have a good evening. All right. With regard to the witnesses who are coming tomorrow, are there any anticipated matters of law?
Yes, sir, Your Honor. One witness, I believe, the defense is calling a pathologist, and there may be some issues regarding that. I'm not entirely sure what they intend to elicit from that pathologist from Charlotte, but there could be, I don't know who else they intend to call.
Honor, what we anticipate for tomorrow is the expert witness, Mr. Schneck. Mr. Schneck's report has been delivered to the solicitor. He is the expert who took a ping sample from the taser and the cell phone and has done a comparison to the chemical composition of the yellow brick road.
I don't think there would be any issues with that testimony, Your Honor.
Thomas Owens is a forensic pathologist from Mecklenburg County. He, Don, will testify to the effects of cocaine. Correct? And he is also has a background in hospitality. Is that correct? Darren Porcher is from New York City. Mr. Porcher is proposed to be introduced as an expert in use of force. And Sergeant Webb is a local witness who was Mr. Slager's immediate supervisor on April 4th, 2015. On Wednesday, we propose another expert from Toronto, Canada, by the name of Eugene Liscio. Mr. Liscio is an expert witness in the field of barrel scanning, and we expect that he will be our last witness of the week. Is that correct? We believe that Schneck, Owens, and he pronounces it Porcher. We would probably say Porcher, but he's from the Bronx and not from South Carolina. So all three of those are either here or on their way. Is that correct? And probably
again, without knowing the specifics of what they intend to do with these witnesses, we may have some matters of law with regards to Dr. Owens and Sergeant Webb, depending on whether or not the defense intends to elicit self-serving hearsay from Mr. Webb. We may have a matter of law with regards to that. And with regards to, is it Lucio, Your Honor, excuse me, he, as Mr. Savage mentioned, is an expert with the Pharaoh scan. I don't know whether we'll have an issue regarding the substance of his testimony, because I still don't have all of the information that was supposed to be provided to us regarding the first shot. I believe that there were some measurements that were conducted. We haven't received anything on that.
We have provided, Your Honor, just so you understand, a Pharaoh scan, and I think you're familiar with this, is a large bit of volume of data that you can move around in, and they have access to the Pharaoh scan. We have 2 items, I think, that have been provided that were camera matched. That there's the camera match from the taser drop and a camera match from the first shot. Well, we'll provide that to you, and we'll make Mr. Lucio, if that hadn't been provided, we'll make him available to you tomorrow. He'll be arriving. But all it is a bit of data in there that we know we're going to talk about. But there's other data in the Pharaoh scan that will step the jury through. But there'll be no work product of Mr. Lucio other than those 2 separate items.
The second of those items is pretty critical, and that is the location and the distances of the first shot, which are nothing that I've seen. And despite the court's order, we've had this discussion before. Again, we may not, once we know what it is, we may not have an objection, but I can't get it. And I've been promised it, and it's not showing up. And even Mr. Lucio himself has provided information to other courts about the need for time in looking at these 3D type models. And I can provide that to this court tomorrow, that their own witness talks about how critical it is to be able to have this information, to look at it and do a critical analysis, and we don't have it.
And Judge, just for the record, the witnesses that the state used, Mr. Bill Williams and Mr. Lucio, have actually talked on the telephone about this, and there was an offer to exchange data, to which Mr. Williams said, we don't need the data. So
That was an offer to exchange raw data, not his final product. And that's not Mr. Williams' call about whether or not we see the final product. That was the court's order. It's been my request, and we still don't have it. If what Mr. Lucio told Mr. Williams is in fact true, that his distance for the first shot is within 1 foot of Mr. Williams, we're probably not going to have an objection. But I just don't know. I don't know what he's come up with now. 2 Saturdays ago, he said something like approximately 1 foot difference between Williams' calculation and his.
And Judge, we will get that, we'll make him available, and as the solicitor is fond of talking about distances, and we're fond of talking about perspective, and we think that perspective is the more important value of this. It's very hard to capture that without providing an entire Pharaoh scan, and we will go through and make sure that she's been provided with everything so that we can work out between us before we get here any issues that we might have, and we're very confident that this solicitor won't have any issues with the product.
We'll see.
All right. We'll be in recess till 9 tomorrow.
Thank you, Judge.